Magistrate Mr. C.I. Boswell, who happened also to be the one who was charged with the issuing of temporary permits to Chief Luthuli, should the latter have necessity to travel out of Stenga for his medical checkups in Durban. This 1967 inquest was preceded by a letter dated the 11th of September 1967, addressed by Boswell to the Secretary of Justice in Pretoria, in bracket an executive arm of the apartheid government, advising the said secretary that the inquest would be held on the 19th September 1967. Footnote, the witness, Mr. Jeffrey Hadaway, who testified in this reopened inquest, described the said letter as an affront to the very principle of and the doctrine of separation of powers, a subversion of justice and the rule of law. It did not end there, but Boswell went on to foretell that the outcome of the said inquest will be that Chief Luthuli's death was brought about by a train accident, and that the members of the Luthuli family would likely not accept the outcome. Boswell, therefore, knew that the conclusion of the inquest would be even before the formal inquest was held.
My lady, the echo emanates from a speaker that has been connected for the proceedings to be audible. It has no impact in terms of the recordings.
Thank you.
Thank you.
As would have been expected, the train driver, Mr. Latigan, together with his crew consisting of the fireman, Mr. Greiling, and the train conductor, Mr. Van Wyk, were amongst the witnesses who submitted affidavits and who testified viva voce at the 1967 inquest. This is evident that they were sure of what the outcome would be, exonerating them as employees of the South African Railway Department of any wrongdoing. Boswell's findings were, and I quote, the deceased died of a fractured skull, cerebral hemorrhage, and contusion of the brain, sustained by the deceased when he was struck by the goods train accidentally, close quotes. As to whether the death came about by any act or omission on the part of any person, Boswell stated the following, and I quote, the evidence does not disclose any criminality on the part of any of the employees of the South African Railways or anyone else, close quotes. The witnesses who were called to give viva voce evidence at the 1967 inquest were limited to the following. In respect of medical practitioners, Dr. G.M. Gregerson, a senior superintendent of the Stenga Hospital, Dr. J.J. Van Zyl, a district surgeon. The other medical practitioner, Mr. M.J. Juve, a neurosurgeon, was not called to testify, but submitted an affidavit which was then submitted to this court as Annexure C of the record. The affidavits of Drs. Gregerson and Dr. Van Zyl were submitted into the record of this inquest and accepted as emanating from the 1967 inquest as Annexures A and B. In respect of the police officers that testified in the 1967 inquest, there was Detective Sergeant C.B.P. Lewis from the South African Rail Police Services, Devon, who posed as an investigating officer. The other police officer was Sergeant Andres P. Berger, whose statement was submitted as Exhibit P in the 1967 inquest record. Further, there was a South African Railways employees, Mr. Latikhan, the train driver, Mr. D.L. Grayling, the fireman on board the train, Mr. P.F. van Wyk, the train conductor on board the train, and Mr. N. Mataba, a laborer of the South African Railways Administration. There were other witnesses who submitted affidavits which were accepted into the evidence, but who were not called to give viva voce evidence. These included the wife of Chief Luthuli, Mrs. Nobukanya Luthuli, Mr. P.F. Papaya, the ambulance driver of Stenger Hospital, Mr. E.T. Kili, a bus rank manager, Ms. E. Mfega, an employee at Chief Albert Luthuli's General Dealer Store in Groundville, and Ms. Z. Gumede, an employee of Chief Albert Luthuli at his sugar cane plantation. The family of Chief Luthuli was never satisfied with and never accepted the result of the 1967 inquest. They were never satisfied with the lack of an in-depth investigation into the circumstances of his death, and have, for the past 58 years, continued to express their dissatisfaction in regard to the finding by Boswell, who presided over the 1967 inquest. To them, Chief Luthuli's death was a well-orchestrated plan to eliminate him. The family and other interested parties approached the National Director of Public Prosecutions to have the death of Chief Luthuli inquest reopened. Pursuant to Section 17, capital letter A of the Inquest Act, number 58 of 1959 as amended, hereinafter referred to as the Act, the Minister of Justice, the Honorable Mr. Ronald Lamola, directed that the inquest should be reopened. Indeed, on the 14th of April 2025, this court ordered that the inquest be reopened. As directed, after having satisfied itself that the jurisdictional facts exist for the inquest to be reopened, this inquest was then reopened. To remind ourselves with what an inquest is, I will quote certain sections of the Inquest Act. This is designed to allay concerns of the general public at large, who always query why this inquest, why reopen an inquest when nobody is going to be charged since they have died. We are mindful of the fact that in terms of the Act that regulates inquest and regulates reopened inquest, Section 17, capital letter A of the Act provides, and I quote, "The Minister may, on the recommendation of the Attorney General concerned, at any time after the determination of an inquest, and if it deems fit, necessary in the interest of justice, request the judge president of the Supreme Court to designate any judge to reopen the inquest, whereupon the judge thus designated shall reopen such inquest. Subsection 17A2. An inquest referred to in subsection 1 shall, subject to the provisions of this Act, as far as possible, be continued and disposed of by the judge so designated on the existing record of the proceedings, and the provisions of section 17, subsection 2 shall, insofar as they are not contrary to the provisions of this section, shall apply mutatis mutandis to such inquest, close quotes. As regards the recording of the findings and usage in section 17, capital letter A, subsection 3B, section 16, subsection 2 and subsection 3 of the Act provides. Section 2, subsection 2, the judicial officer holding an inquest shall record a finding upon inquest as to the identity of the deceased, as to the cause or likely cause of death, as to the date of death, and as to whether the death was brought about by any act or omission prima facie involving or amounting to an offense on the part of any person. Subsection 3 reads, if the judicial officer is unable to record any finding, he shall record that fact. An inquest, therefore, is an inquisitorial cum investigation process driven by the presiding officer. The state's contention, right at the outset, was that the finding should be made by this court, which differs from the finding made by the 1967 Inquest Court under case number 76 of 1967. The state then presented evidence by several witnesses to justify its contention that Chief Luthuli was murdered, and that those responsible for his murder, alternatively culpable homicide, and a crime against humanity in contravention of the relevant customary international law and section 233 of the Constitution of the Republic of South Africa, Act 108 of 1996, should be held liable by direct conduct vicariously or vicariously liable as authorities in charge of those who executed these crimes. Now, the issues for determination before this reopened inquest were, firstly, whether there exists evidence which was not presented before the initial inquest, number 76 of 1967, necessitating that this court makes a fresh finding in terms of section 17, capital letter A, subsection 3, read with section 16, subsection 2 of the Act. Secondly, to determine whether the proceedings conformed with the prescripts of the Act in ensuring that a thorough investigation into the circumstances around the death of Chief Luthuli was pursued by that court under Inquest number 76 of 67. Thirdly, whether that court was presented with sufficient evidence to make credible prima facie findings in terms of section 16, subsection 2 of the Act. In looking at the above mentioned issues, this court is reminded of what was stated in the case of Timor versus Magistrate of Johannesburg, 1972, Volume 2, SA 281 T at 287 to 288A. And I quote, sorry, before I quote that, the same sentiments were echoed by Seeley, JP, and Murray, J. And I quote, for the administration of justice to be complete and to instill confidence, it is necessary that, amongst other, there should be an official investigation in every situation where a person has died of unnatural causes, and the result of such investigation should be made known. Therefore, the Inquest Act provides that if there is reason to believe that the death has occurred, that such death was not due to natural causes, and that it was not followed by the institution of criminal proceedings, there shall be an inquest as to the circumstances of that death, close quotes. Therefore, the inquest must promote public confidence, as it was held in the Earth, NO versus Tiley, where it was held that, and I quote, the underlying purpose of an inquest is to promote public confidence and satisfaction, to reassure the public that the deaths from unnatural causes will receive proper attention and the investigation, so that, where necessary, appropriate measures can be taken to prevent similar occurrences. And so that persons responsible for such deaths may, as far as possible, be brought to justice. The state seeks an order which, in my view, is justified by the voluminous evidence that has been presented before me by various witnesses, whose details are listed in paragraph 12 below. The order sought may be summarized as consisting of 3 parts, namely, 1, that the finding and ruling of the magistrate Boswell, dated 19 September 1967, at the Stenger Magistrates Court under Inquest number 76 of 1967, be set aside. Number 2, that the finding pursuant to section 16, subsection 2A to C be made. That a finding pursuant to section 16, subsection 2D of the Act be made. Closing argument was presented to justify and to convince this court that indeed there is abundant evidence to justify the granting of the order sought. This judgment incorporates such closing argument without singling it separately, especially as there is no counter-argument for this court to find otherwise. I must express my gratitude and acknowledgement of the sterling work by the prosecuting team of painstakingly presenting this case before me. I shall now deal with a brief summary of the evidence presented. As per mutual agreement with the prosecuting team, I shall not deal with the detailed evidence of all the witnesses who testified. The evidence tendered at this reopened inquest included oral and documentary evidence of 3 investigating officers, who were assigned to investigate this matter from 2021 under the TRC/Apartheid Era Crimes Unit. Witnesses in the persons of Captain G.F. Khamanyane, Colonel Madimetsa J. Motle, Lieutenant Colonel Thomas Johannes Day. Collectively, they traced the whereabouts of the 1967 personnel, doctors and police officers involved in the initial inquest. Lieutenant Stein further traced the whereabouts of other potential eyewitnesses, with the last notable one being Mbemu Mnyandu, who had been sent by his father, Mnyandu, to deliver a letter to Chief Luthuli on the 21st of July, 1967, only to witness him, that is Chief Luthuli, being assaulted by the white men from the train, which was stationary in the vicinity. In bracket, much about this will be said later. He made reference to Exhibit B, C, DD, and FF, as well as FF1. Secondly, there was oral and documentary evidence of a representative of the African National Congress, the ANC, of which Chief Luthuli was President General, with Oliver Tambo being Chief Luthuli's deputy. This was presented by Mr. Jeffrey Tamsanga Khatebe, a high-ranking member of the ANC, who gave evidence from a political perspective detailing the political life of Chief Albert Luthuli. He outlined the political motive behind the killing of Chief Luthuli, dispelling the notion of a train accident. Mr. Khatebe testified about the role that Chief Luthuli played in developing, guiding, and reshaping the thoughts of those who were oppressed by the apartheid regime. How Chief Luthuli advocated and fought for the emancipation of the black oppressed people of South Africa. How he pushed for the gradual shift from passive resistance to armed struggle, despite the media portraying him as a passive lame duck who was under the apartheid government oppression. Mr. Khatebe further enlightened the public about how Chief Luthuli was voted as the President General of the ANC in the presence and attendance of youth leaders such as Nelson Mandela, Walter Sisulu, inter alia, who all grew under the stewardship of Chief Luthuli, reporting to him on all underground operations pertaining to the ANC, even after it was banned in 1960. He further gave an overview of the struggle credentials of Chief Luthuli and his involvement in formations such as the Natal Indian Congress, the Congress of the Democrats, the Colored Congress, and others. In 1955, under Chief Luthuli, the Congress of the People was held, out of which the Freedom Charter was born. Chief Luthuli advocated against forced removals of black people from places like Sophia Town, Ketomena, and Mkumbani, to name but a few. Banning orders were the order of the day, culminating in a number of people living under banning orders at specific times. This became even more evident in 1966 when the American Senator Robert Kennedy visited Groundville. Chief Luthuli, however, could not speak to him in the presence of other people. It was soon after this, that is the period of the visit in June 1966, that in 1967, Chief Luthuli was assassinated by forces of the apartheid regime. This matter was covered up as a goods train accident. Mr. Hadebe cited extracts from books in the likes of Comrade the Commander, The Life and Times of Joe Modise, in reference to meetings held in the sugarcane fields chaired by Chief Luthuli in 1962. He further referred to the book title, a book by Chief Albert Luthuli titled, Let My People Go, symbolizing the hardship and pain Chief Luthuli was going through, for which he paid the ultimate price of death. Chief Luthuli was regarded by the apartheid-era government as a slippery irritation whom they wanted to get rid of. Mr. Hadebe highlighted the animosity of the then apartheid government, which was displayed when Chief Luthuli was awarded the Nobel Peace Prize in 1961. Thirdly, oral evidence by family and persons associated with Chief Luthuli and his family, and these included the following: Mrs. Velemina May Luthuli, affectionately known as Veli, who was a daughter-in-law of Chief Albert Luthuli. Mr. Mthunzi Albert Luthuli, the first male grandson and eldest of the Luthuli grandsons. Dr. Albertina Nomatuli Luthuli, currently aged about 93 years old, who is the daughter of Chief Albert Luthuli and who was a qualified medical doctor at the time of Chief Luthuli's death. The evidence of these close family members was to demonstrate that Chief Luthuli was fit and healthy, was not hard of hearing, as supposed by the witnesses of the apartheid regime, and that his sight was not impaired such that he would not have seen the oncoming train. His hearing was also not so impaired that he would not even hear a whistle or the sound of the train as it passed over the Umvoti River Bridge. According to the family members, that it had made matters worse, heightening the negativity and culminating in Chief Luthuli's assassination in 1967. She further testified that even after Chief Luthuli's death, the family continued to suffer and be subjected to harassment, to the extent that in the year 1970, she and her husband, Dr. Ngakane, who was also under banning orders, together with their children, went into exile, only to return to the Republic of South Africa in 1991. It was only after her return from exile that she followed up the matter and eventually got hold of a copy of the post-mortem report compiled by Dr. Van Zyl, that is Exhibit D, from Stenger Hospital. As a qualified medical practitioner, she raised alarms about the glaring shortcomings and inconsistencies in the report. To the best of her knowledge, no family member was called upon to present and give evidence at the 1967 inquest hearing, despite that they were still resident in Stenger. The other witness from the family and close associates was Mrs. Nozizwe Abigail Mhlongo, born Mabaso. She is aged 67 years, and as well as Elliot Fanyana Ngumalo, aged 89 years. They testified about Chief Luthuli as an individual outside of his family setting, there and then providing this court with a perspective of how highly Chief Luthuli was regarded in the community of Groundville. They also echoed the sentiments as a young schoolgirl. She would deliver correspondence and or letters that Chief Luthuli was sending to other underground activists. As a school child, she did not fully appreciate the bag containing the letters to and from Chief Luthuli. Mr. Ngumalo testified that during the 1960s, even talking about or mentioning the name Chief Luthuli was taboo, as it would attract trouble with the police. She testified that on the afternoon of Mr. Ngumalo testified that on the afternoon of the incident, 21 July 1967, he accompanied Mr. Mabaso, the father to Mrs. Mhlongo, to the scene at the Umvoti train bridge, where they cleaned the blood of Chief Luthuli. A further witness in the name of Stanley Tusi testified that he is employed at the Thuli Museum, which is situated at the former home of Chief Luthuli. He gave interviews and pointed out variable points to a photographer from the local criminal record center, commonly known as the LCRC. That photographer was Constable Lukwazi, and to Warrant Officer Beges of the Forensic Reconstruction Unit attached to the SAPS in Pretoria. This has been confirmed by Warrant Officer Beges in his Exhibit F1. These points pertain to the daily or regular routes that Chief Luthuli walked from his home to his shop in Guanonkevu and to his cane fields, including the walk over the Umvoti railway bridge. He referred to Exhibit N. He referred to a steel bridge running over Nchaweni River near Gledo Sugar Mill, and said this is similar to the old Umvoti River Bridge, which was subsequently demolished after the demise of Chief Luthuli. He further, at a later stage in the proceedings, testified in respect of the photographs of the procession at Chief Luthuli's funeral. With reference to these photographs, it was clear that the body of Chief Luthuli was intact and not dismembered. And as he lay in his coffin, it was a complete body, unlike the situation where a person who's knocked by a train would have his body dismembered. Mr. Brian Kaba testified with reference to his affidavit Exhibit O and told this court that the 1967 inquest documents were downloaded with his assistance, and these were handed to Captain Khamanyana. The duplicates of these documents are kept at the Luthuli Museum in Graveville. There was also oral evidence of Mr. Mohammed Hanif Manju, aged 81, who was present as an admission clerk at the Stenger Hospital when Chief Luthuli was wheeled in, lying in a stretcher on the 21st of July 1967 at about 11:30 in the morning. He knew Chief Luthuli very well since about 1959, when he was a young boy of the Manju family. He frequently drove Chief Luthuli back to his home after the latter had been to a meeting with his father. His father was Mr. E.V. Mohammed, a bookkeeper and friend of Chief Luthuli. His evidence is that on the 21st of July 1967, whilst on duty, he received a phone call from the station master of Gledo railway station requesting for an ambulance to be sent to the station for a native who had been knocked by a train. His recollection is that it was a certain Mr. Zwane who was dispatched to drive the ambulance and not Papaya, as the 1967 inquest records reveal. When Zwane came back into the outpatient unit, Manju immediately recognized Chief Luthuli as the patient who was being wheeled in. Chief Luthuli was unconscious. Manju did not see any bruising or bleeding on the face or on the head. However, he considered that if there was bleeding at the back of the head, he would not have seen it. In due course, Chief Luthuli was taken into the examination room, and one Dr. Mizra, a district surgeon, was called to attend to the injured Chief Luthuli. Dr. Gregerson, the senior superintendent, was also in attendance. Manju found this strange that Dr. Gregerson, as senior superintendent, was not expected to attend to patients, especially black patients. Another documentary and oral evidence was presented by expert witnesses, namely Warrant Officer B.C. Bejes, Warrant Officer Sunek Nel, Mr. Gert Willem van Donder, Mr. Leslie Labuskaghni, Dr. Sibusiso Ntsele. Coincidentally, Dr. Ntsele is from Chief Albert Luthuli Hospital in Durban. It is tried that an occurrence of a train or a motor vehicle accident, for that matter, or an aeroplane, requires evidence of a technical, forensic, and pathological nature to be led to prove, firstly, that there was such an accident, and secondly, its probable cause. In this reopened inquest, evidence was led of 2 train experts, evidence of a reconstruction expert, evidence of a simulation expert, and a specialist forensic pathologist. It would be remembered that no such expert evidence was adduced in the 1967 inquest. The expert witnesses that were called at this reopened inquest had the mammoth task of determining if a train accident did indeed occur, and if so, whether the injuries found on the body of Chief Luthuli were consistent with those of a train accident. The official who was assigned to reconstruct the alleged train accident is Warrant Officer Burgess. That is, after attempts to engage private reconstruction expert failed. Warrant Officer Burgess gathered information from Mr. Labuskachne and Mr. Van Donder, who are trained experts. For purposes of simulation, he used Warrant Officer Sunette Nell, who happened to be of the same height and weight as Chief Luthuli. For the forensic analysis of the post-mortem report, he engaged the services of Dr. Nzele. I propose that we take a break at this juncture and resume at 11:30. Sorry, I can't get out of this bench. Can we sit again? Sorry. Quarter chance.
All right.
Yeah.
It is all understood. It is all understood.
That is when it makes noise.
Yes, but was the lead prosecutor in that matter years back, you see.
Where did I see this?
Yeah, it's right.